Okay, welcome. We're going to go ahead and start while the last few people are serving themselves because I want to take advantage of the time we have here with Robin Mardemootoo. And some of you turned out because you know about him from my class, but others of you are here because you've learned about it from other folks, and it's terrific to have this turnout. I've been waiting for this. So I'm Karen Engel, and I teach here at the law school, and I'm co-director of the Rapoport Center for Human Rights and Justice. And we've been trying to get Robin Mardemootoo here for a long time, and he just happened to come for vacation, and we're taking advantage of it. And he claims that this is what he likes to do on vacation. And I know about him and his work from Michael Tiger, who used to be a professor here, and who actually, I thought Robin had studied with here, but he studied with him before that in France, and I'll say something about that in introducing him. And they've worked together on a number of cases, and one of the major ones being the case, various aspects of the Chagos Islanders and litigation in a variety of fora. So I will say for my human rights class, this is really terrific because you get to see 4 different ways in which, or 4 different fora that are being used to litigate a case. And of course, we always say in human rights you can only go to one forum, but they've figured out ways to raise issues in different postures that defy that idea. So you all know a bit about Robin because you've read a bit about him. I'll introduce him anyway and say a couple of other things. I want to thank the Institute for Transnational Law and Lauren Fielder, and who is the director of that, and the Human Rights Law Society. And I don't actually know who all to thank at the Human Rights Law Society right now. Okay, so. And there's several, you'll have a number of folks here right as well. So thanks a lot. Okay, so Robin Mardemootoo he's here as a human rights lawyer, but he's also a corporate lawyer. In fact, he's the managing partner of Mardemootoo Solicitors, where he heads the banking, corporate finance, and commercial practices. So some of you should feel free to ask about that as well. He holds a master's in law from Aix-en-Provence in France, which is where he first met Michael Tiger. And he also holds an LLM from the University of Texas School of Law. And so that's one of the reasons we've been wanting to get him back for a long time. So I know there are a number of LLMs in the room who might out themselves to you and talk to you about life after LLMs. He specializes as a corporate lawyer in securities regulation and laws related to banking, corporate finance, cross-border investments, and international taxation. And he's been ranked as a leading lawyer by several online resources globally for professionals in financial law. But he's talking to us today, partly in his capacity as the founder of Speak Human Rights and Environmental Initiative, which is a pro bono arm of his law firm. And it's a standalone organization dedicated to promoting international human rights worldwide through litigation and education. And so, as I said, he'll talk today about his involvement in the Chagos Islands case, but I think he's also open to, he's going to leave time for questions and open to talking about really pretty much any facet of his international law practice and how Austin has changed in the last 20 years. So thanks for coming back, Robin.
Thank you, Karen. Thank you for having me. Hi, everyone. Yes, I'm here predominantly to talk about my involvement in the Chagos Islands litigation. But when we're done, I'll be happy to answer your question because my predominant activity and practice is banking and corporate finance. But there's this thing in my part of the world where lawyers who do human rights lack resources. And so one of my primary objectives was to ensure that human rights litigation in this part of the world, in that part of the world, benefited from the same resources which were available to the powerful actors, namely banks. And and multinationals. So that's why we've created that pro bono arm to engage into effective advocacy and litigation of human rights and environmental issues. So, with due respect, I don't mean to offend anybody about the geographical knowledge of Americans, but I wanted to know that you know what we're talking about. This is Africa, Madagascar. There's a small island here called Réunion Island. Then there's a small island here called Mauritius. I'm married to a girl from California for 26 years. And I have to tell you, every time I've been asked, 1,000 times, where are you from? I said, I'm from Mauritius. Never heard. What's that? Where is that? And I always refer to it. It's an island off the coast of Madagascar. Oh yeah, I like the film. So I always found Madagascar reference to be very useful. And then up here, famous group islands called the Seychelles, very beautiful islands. And then here is the Chagos archipelago. And of course, up here is India, Singapore, and Australia. And here, there's a small island, probably around here, Aldabra Island. I'll tell you why it's interesting afterwards. So, we are in 1960s, at the peak of the Cold War, and America is in search of a base in this area of the world for geopolitical reasons. So, America contacts the UK and asks the UK to facilitate in giving an island for a military base. And UK says, well, go ahead and pick. And America, I think it was a US Navy team, selected Aldabra Island first as a priority place. And then number 2, Diego Garcia, which is the main island of 65 islands in the archipelago of the Chagos. Diego Garcia is famous because it's in the form of a horse, how do you call that, a horseshoe in English, with great safety, security facilities, because to get inside the bay, you would need to pass a particular post here. But, so America decided against Aldabra for a simple reason. Aldabra had no human population, but had a unique turtle population, and they did not want to disturb the turtle population on Aldabra. So hence, they went for the option number 2, which is Diego Garcia, part of the Chagos archipelago, where they didn't have turtle, but they had indigenous people. And they therefore decided that this would be the place where they would make one of the most important military bases. And to facilitate their installation on the island, they resolved with the British government to evict the indigenous people out of the islands. And so this is what the Chagos litigation is about. The forcible removal of the indigenous people from the islands of the Chagos to make way for American military base. Now, so Diego Garcia is on here, and all the other islands are, scattered. The closest island, the closest livable island to Diego Garcia is an island called Peros Banos, which is about 200 miles away from Diego Garcia, and it's a lot. But they did not decide to only remove people from Diego Garcia, they removed people from everywhere, and basically dispatched them to Mauritius and to the Seychelles. Now, these people were indigenous. They had their own way of livelihood. They had their own food, their own alcohol, basically based on copra plantation, which is coconut plantation. So everything revolved around fishing, agriculture, and agriculture. So the U.S. and UK agreed to remove everybody from the Chagos. And how would they do that? So all these Indian Ocean islands, they don't speak the same language. Someone from Madagascar doesn't speak the same language as someone from Mauritius. But the accents and they have their own dialects. Réunion, Mauritius, Seychelles, Maldives, and the Chagos. At the base, maybe it's a cool French, but if you listen carefully, maybe you will understand each other. Just to tell you that they also had their own linguistic individuality, identity rather. So how to remove them out of those islands? And at that time, Mauritius was a UK colony, and part of Mauritius was attached to, Chagos was attached to Mauritius. Another island here called Rodrigues was also attached to Mauritius, and another group of islands here called St. Brendan also attached to Mauritius. So Mauritius was the main dependent, and all those little islands were attached to Mauritius. So when someone was sick on Diego Garcia, they would be transferred to Mauritius for treatment. There would be exchange of teachers, Catholic priests, magistrates would travel from Mauritius to Chagos. All right? So they decided to remove Mauritius, and this would be this part, which I'm going to tell you now over the next 3 minutes, going to be essential when it comes to violation of Article 1(2) of UN Charter and UN General Assembly Resolution 1514 and 2066 about decolonization. Why? Because, as you know, the primary objective of the UN Charter is, under Article 1, to enhance and develop friendly relations among nations through, notably, self-determination of peoples. And Article 73E gives an obligation to colonial empires to actively report on the process of decolonization. How are you going on about decolonizing your territories? And the point where I'm coming is the UK, as the colonial power, did exactly the contrary. So, as part of its reporting to the UN on what it was doing for decolonization, the UK and the US decided to create a fiction that those islands, there were no population on those islands. And that was a policy decided jointly by the UK and the US. And there are minutes of proceedings of official meetings where not only they decided to create that fiction, but also to maintain that fiction over the years in order to comply with Article 73E of the UN Charter. And in fact, there is a minutes dated 23rd October 1968 by a legal advisor to the British government called Anthony Oast, and he is the one who took the initiative of that advice. Create the fiction and maintain that fiction. And also make the rules as we go. So that is very relevant, that knowledge of the UN Charter is very relevant to what happens afterwards when they decided to remove the people. So they removed the people. They couldn't remove the people in a direct way. So one of the ways they decided to remove the people was to stop sending food to the island. The island was pretty self-sufficient except for like rice, flour, oil, sugar, the basic amenities. So the UK and US decided to ban the imports of basic commodities to the island, hopefully to get the people out, number one. Number two, they decided to retrieve Catholic priests, nurses, and teachers, and people of, although they are indigenous, but they are deep believers and practicing Catholics. So they knew, the UK and the US knew that by removing priests from there, and so therefore stop prayers at the churches, that would have an effect, at least a psychological effect on the population. So that was the number two way. So you've got a whole generation of Chagos kids who grew up without milk because they decided to stop sending milk there. And the third way was, when really that was the last resort to get, the third way was people who went to Mauritius on vacation or for treatment or for marriage or for education were denied the boat trip back to Mauritius. So, and when that would happen, they've got their houses, they've got their domestic animals there. So they would just show up to buy a ticket, and the ticket office would say, no, sorry, there's no place on the boat, so you can't go. So people were stuck, or left stranded in Mauritius and in the Seychelles and couldn't go back home. So that was the three indirect ways of depopulating the islands. And then came the direct way, which was by such date, you guys have to vacate. And it's fairly well documented how this happened. They started by killing all the domestic animals. There were dogs in the Chagos, people had dogs. Want to say something?
How many people were they trying to remove in total?
About 3,000, 3,500. So the population had dogs, of course, dogs. I'm not sure whether they were cats, but dogs and donkeys were among the pets. So one day, the British and American officials asked them to bring all their dogs to I don't know if it's an English word, a hanger like a barn. Bring all the dogs here. So they did, and put all the dogs in the hangar. And then there were 3 military jeeps, Land Rovers, who were switched on, and the dogs were gas chambered. Probably about 750 to 900 dogs. I'm not too sure about the numbers, but in that area. So that was a big psychological blow for the people. When I see them, they're still reminiscing about this episode because it wasn't organized. And the owners had brought their dogs there, and they could hear the dogs, make noise when they were being killed. And still, of course, today the only people who remember this would be the natives, because out of the 3,000 or so natives, there's only 300 to 350 who were still alive. The rest died. So, but of course, they told that to their children and their grandchildren. So, after they killed the dogs, then they decided to force them into boats that were used to pick up. Do you know guano? Are you familiar with guano? Bird fertilizers. There was a boat called North there, MV North there, who used to travel the Indian Ocean and pick guanos and for export rather. So they would wait for that boat to come around and then put a tarpaulin on top of the guanos and get the people on. And so that was about a week to 10 days trip to either the Seychelles. Seychelles was probably in 5 days, Mauritius was 10 days. Very traumatic experience also for people to travel that way. Overcrowded. You would think you're watching a horror movie, but that really happened under lawful removal. So this is how they were removed from the islands. And so when they arrive in Mauritius, for example, the whole thing started. The whole depopulation started about 1968, and the last bit occurred in 1971. And but by that time, so US had already chosen this, and they had already gone to UK and said, we want Diego Garcia, we want Chagos, but we need you to detach the Chagos from Mauritius ASAP, so that there's no political interference. And in 1965, the UK created this territory, gave it a new name called British Indian Ocean Territory. So there is an order in council of 1965, which created the Bayat, as they call it. Are you guys familiar with an order in council? An order in council is an order made by royal prerogative. In England, just like here, I suppose, you make law by the Parliament, by your Congress. But in England, there is also a way for the Queen to legislate. And she can do that by an order in council. So whenever you don't want, well not you, whenever the legislature don't want to go through the normal channel and get debates on an issue, they go to the Queen, because there's no debate there, and they get her to pass by virtue of royal prerogative and order in council. So, and that order in council, insofar as non-UK matters are concerned, therefore for all of the Commonwealth around the world, is considered primary legislation, as good as an act of Parliament. So, order in council in 1965 created a new territory called the Bayat, and therefore detached the Chagos from Mauritius. So, why am I telling you all this? When this happened, the Bayat citizens of Chagos Archipelago were therefore dumped on a foreign territory. And in 1971, when the actual removal came in, Mauritius had already become independent. In fact, we just celebrated our 50th anniversary on 12 March of independence. So in 1968, Mauritius became independent. So in 71, UK and US dumped them in Mauritius. And there's no transition, there's no adaptation, there is no, I mean, imagine today being forcibly moved to not only another village or another town or another state, but to another country. There's nothing. Nothing is prepared for them. So they are dumped on the quay with whatever they could have packed. Of course, they've left most in the islands. And that is the start of 50 years and ongoing human tragedy. These are people who had no idea how to survive in an organized society. No cash, no, I don't know, I think it was a pretty good, but certainly no cash, and no knowledge on how to and there was nothing there to help them adapt. So that is the end of that first part that I wanted to share with you about. From that time they came to see me in 1997. I finished here in 1995. So between 1971 and 1997, they tried to organize protests on the street. They tried to go to the US Embassy, the UK Embassy, what it's called UK High Commission, and for help, because they clearly weren't adapting, and they would be given like soccer balls, badminton things to help recreation, but there's no solution. So they came to me in 1997. Somehow between 1981, Margaret Thatcher came to Mauritius, I think, and gave some financial help to them. I think about $800 per family, but by that time they were so indebted that it's their creditors who got right to the money immediately, and they saw no trace of that money. So came to see me in 1997. So now I start on the litigation aspect of the file. I will talk to you about 4 litigation track, but as briefly as I can. There is the UK litigation. There is a very small US litigation, which will take 1 minute. Then there is the EU litigation, and then there is the UN litigation. UK litigation. So the first thing I did when they came to see me was, okay, you guys are British Indian Ocean Territory citizens. What in law is preventing you from going back to your islands? Because it must be organized in law, right? There must be some kind of prohibition. So I found out, well, the first thing I did as a lawyer, second thing. The first thing I did was, I researched what was the applicable law and what was the prohibition. So, in 1997, I found out that there was a secondary legislation called the Bayat Immigration Ordinance of 1971, which had been enacted by the Bayat Commissioner, because when the Queen created the Ordinance Council in 1965, it gave Bayat its own constitution, and in the constitution it provided that the main guy who's going to run the show is a commissioner. Call him Bayat Commissioner, and that guy is going to have the powers to make rules, secondary legislation to run the islands. Are you guys okay with this so far? So that guy, commissioner here, under the powers of that constitution, created Immigration Ordinance of 1971, which ordinance said it shall be unlawful for anybody to be on the islands without a license. That is the legal instrument which prevented them from being on the islands. So our duty was to go to court and challenge this immigration ordinance. So as a lawyer, what do you do? So I said, which court am I going to go? Because based on that constitution, there is a Bayat court. Well, where is the Bayat court? And how do I get to Bayat court? And the Bayat court supposedly in Chagos, but there's no transport there. And so I said, okay, look further, and we've seen that they had a second office in London. Guess where? And so the Bayat Commissioner sits in London, and also said English courts could have jurisdiction over Bayat matters, but primarily Bayat court. But since there were no Bayat courts, that became English courts. So then, who is going to fund all this? It's unrealistic to start litigation against the UK government in London without a proper funding strategy, because you would do harm to your client if you don't have a clear path as to who is going to sustain the cost, because legal proceedings cost. There's no doubt about this. So we wrote to, so I appointed a firm called Sheridan's in England. At that time, later, we moved to Clifford Chance, and a lot of people say a lot of things about big law firms, but sometimes they can be really helpful. Clifford Chance has been acting pro bono, well, on legal aid for the past 15 years, which is a massive benefit to them and to us. So we got legal aid. We got legal aid to sue the UK government. Once we got that out of the way, then we started the process. And what would be the process? Under English law, I know you probably have the same concept of judicial review. In the US, judicial review is the way you challenge an administrative decision by your government under administrative law. So we started judicial review, and mind you, they took all kinds of preliminary objections. You guys should have gone to Bayat court, and you guys are time barred, because a fundamental principle of judicial review under English law is you have to attack the impugned decision within 3 months of its passing. Here we're attacking an instrument of 1971. In 1997, we were, 26 years late. But they nonetheless took those objections. And several other objections. And the English judge set aside all of their objections and gave us permission. English judicial review is in 2 steps. You've got to go to a judge and ask for permission. And it's like a filter from good cases to bad cases, because there's so many cases. And if he gives you permission, then you go for a substantive judicial review. So he gave us permission in 1998, and we then filed a proper judicial review application. And on 3rd November 2000, the UK High Court quashed this immigration ordinance and declared it repugnant, and that was the end of the prohibition. That was a fantastic victory, and they had their day in court, and everybody was very happy. Then enter America. So we were preparing, because of course UK government would not do anything to help them go back. Okay, this is squash, but find your way out to there by your own. So I remember we were looking for contributions to buy a ship and to enable them to go back. In the middle of the whole thing came a very tragic event which changed the course of their history. You guys have a clue?
9/11.
Exactly. 9/11 came. And of course we were all deeply shocked and moved, and I promise you, I told myself, that is going to change the course of this whole litigation. I mean, don't get me wrong. Of course, 9/11 was tragic, and we're still paying for its consequences. But I couldn't help thinking about my litigation, with what effect 9/11 is going to have on my litigation. Diego Garcia is right here. Iraq is somewhere here. Afghanistan is somewhere here. This is more important to the US government than Guantanamo Bay, because this is far from the eyes of Congress. What goes on in Diego Garcia, nobody knows. The rendition fights, it's there. Things that go on in Diego Garcia, I mean, it's well documented, but anyway, that's not the purpose of this talk. This class, of this lecture, I'll talk. 9/11 came, and little did you know that in 2004, we got the shock that the Queen, again, had enacted another order in council, 2004, to reinstate the ban that was quashed by the court here. And I forgot to tell you something very important. When that on the 3rd November 2000, when that ordinance was quashed, the Foreign Affairs Minister, I think in here you would call the Secretary for Foreign Affairs, State for Foreign Affairs, there was a guy called Robin Cook, famous English politician. He was minister there, and he immediately said, I'm not going to appeal against this judgment. That is very important for the expectation. You know, there's fundamental principles in judicial review, which is administrative law, the legitimate expectation that you create in someone. And you're not allowed to disappoint a legitimate expectation. That's it. That's a ground for judicial review, at least under English administrative law. So, by saying we're not appealing against the judgment, he's sealing the fate with a legitimate expectation that they're all going back. So in 2004, there's no way this guy comes back with an ordinance who's been quashed. Because, one of the terms used by the judge is Section 4 of the 1965 Constitution said, you, the commissioner, can make laws, can make rules and regulations for the Bayat for the peace, order, and good government of the islands. And you will see those terms, peace, order, and good government, in all Commonwealth countries' constitutions, because that is the test, that is the standard for governing a territory in the English Dominion. So the High Court said, you had the power to legislate for the peace, order, and good government of your island, and that certainly could include removing them from the island. So that was how it got quashed. So anyway, 2004, the Queen reenacts the ban, and we said, what the hell are we going to do now? Why? Because here it was a commissioner, an immigration ordinance, but here it was the Queen. The Queen was immune. You can't quash, you can't challenge the Queen's primary legislation. We did not challenge the 1965 Order in Council. We challenged the Ordinance of 1971, which was not from the Queen, which was done on the authority of that Constitution. The Constitution was not unlawful itself. It just said, govern the island for peace, with peace, order, and good government. That guy did the prohibition there. So in 2004, we had to decide to go to court for the first time in British constitutional history to challenge an order in council. And in 2005, we won. Unanimous bench. The High Court quashed the order in council. The UK government appealed. The Court of Appeal unanimously ruled in our favor and rejected the appeal. And then they went to the House of Lords, the UK Supreme Court, and then the hearing. Before I go to the hearing, somewhere before here, after 9/11, but before 2004, the UK government commissioned a feasibility study because they've lost this case. So they appointed a group of experts, they handpicked a group of experts, said, is it feasible to go back to these islands nowadays with climate change, rising of the water? And in 2002, so that happened in 2002. So when we went to court in 2004 to challenge the Queen's decision, the British government told us, what are you doing? You can't go back to the islands anymore because water has risen, climate has changed. I told them, what have the Americans gone then? I mean, if water has risen. No, they're still there. So can we have a copy of the feasibility study? We'll look into it, but they have no choice because they've already been brought to proceedings. So they said, part 1 is not available, we have misplaced it. Part 2A is not available. Part 2B is available. And part 3 no, part 4 no, and part 5 yes. So we went to court on that basis. And before the House of Lords, best Supreme Court ever, with due respect to your own, we lost 3-2. The Chief Justice was in our favor, Lord Bingham, great judge. But 3 judges had voiced against us, including Lord Hoffman, who was involved in the Pinochet case. Why did they rule against us? Because they said Part 2B had concluded not feasible to settle in the islands, no longer feasible. You can't go back there. So Lord Hoffman said, why are we even wasting our time talking about the rights of these guys to go back on the islands when they cannot go back on the islands anyway, according to this report? Okay, well, what do? UK Supreme Court ruled, so we stopped all the initiatives. We had been starting all kinds of capacity building exercise to train those guys into masonry, carpentry, engineering, because they had to take care of their own islands. And so that judgment came and knocked all of us out. Until, in the course of another litigation, but which I won't go into because it's not a primary litigation, my time is running out, the English government's legal team blundered when we were in discovery. We don't really have discovery in England. When they sent papers, which we had applied for, guess what they sent? And it's a new legal team. And they just sent a container of documents. And we were shocked to see this. And when we saw this, we saw that they appointed 5 experts. 3 experts had said, no, the islands are perfectly livable. There's no problem in sending them back. 2 experts said, no, it's not feasible. And the 3 experts resigned and were not replaced. And 2B was sent, redacted, just on the authority of the 2 experts. We didn't know what to do again because Supreme Court had already ruled and there is no precedent in you going to the Supreme Court and challenging the Supreme Court on the basis of what you've discovered. There's an old English law principle, which I don't know if it exists here, called the duty of candor. The duty of candor requires a litigator to play it fair. And we argued that they breached the duty of candor by concealing the you guys must have that here. So we petitioned the Supreme Court again. And again, they have that. They have to filter it. They accepted it to the shock of the UK government. And then there we were before the full panel of the House of Lords. And I can tell you, it was embarrassing for everyone. I mean, the British people and the British lawyers and the British judges, they take themselves very seriously and very proud of their system, and rightly so. But here was a moment of embarrassment, because clearly the UK government had misled us. And unfortunately for us, and this is the intricacies of litigation, so that was in 2014, 2014, just a few months before the House of Lords hearing, the UK government had appointed KPMG, global advisory firm, to advise on feasibility of resettlement in the islands, and KPMG had said, perfectly feasible. You guys can go back there, no problem. So, when we came before the Supreme Court in 2014, the judges were informed of a big dilemma. What are we going to do? Because if we say yes, we'll go back and change our own judgment on account of this. This will open a floodgate of litigation. There will be all kinds of reasons to change what is supposed to be a final judgment. So, they got away with this feasibility study. They said, guys, everything that happened, unacceptable, but we don't consider it to be absolutely essential for us to go back there, because it will open the floodgate. We suggest that you go back to the government and you say, enforce the feasibility study of KPMG now, because now we can go. And if you have a problem, come back to us, and we will do what we have to do. Okay? But that's the unfairness of human rights issues. It's easy for them. I understand why they did this. I do understand. But these guys, they are the poorest people. And we are now what? 17th year of pro bono litigation. You just run out of resources. You run out of energy litigating that kind of. And I'm still here. We're not even here. Here is a joke, but it's amazing. It's just amazing. So, of course, we went back to the UK government. They did nothing. And now we're back in court, forcing the UK government to send us back there on account of everything that had happened. And that hearing is later this year. So that is what I wanted to tell you about the UK litigation. Everything else will go very fast now. US, well, in 2000 we went to the US District Court. They ruled that it was a political question doctrine, and they would not interfere. Although we tried to argue that we were not challenging US government policy, no. Non-justiciable, because it's a political question. The Court of Appeal upheld that ruling, and so did the Supreme Court. So that's the US. We have one other, besides the political question doctrine, there was also another, I think you have another principle under US law where if an alien suffers a prejudice outside America, the US courts have no jurisdiction to determine that prejudice or that claim, although, notwithstanding the fact that it's the US government who committed that prejudice. So, okay, what do you want me to do? Which court do you want me to go? So, US government caused a prejudice to a bunch of people outside America, and I cannot come to America for justice. I can't go to England because there is foreign sovereign immunity principle. No country will allow you to sue another country before their forum. They will send you back to their country because domestic courts have got powers over their government, but foreign courts don't. So what do we do? This was a problem, and so we forgot about that. So that was US. EU, again, the beauty of international human rights litigation. We argued a whole array of European Convention of Human Rights violations, but the conclusion was when the Queen legislated in 1965, they were very careful to send a note to Europe to say, by the way, Mauritius, which when Mauritius was a colony, we had extended the whole of Mauritius territory we had listed them as European Convention territory, meaning the European Convention applies to these territories. Here, the UK deactivated the Chagos. One of the first things they did was to write to the European Convention Secretariat and said, remove the Chagos territory from the European Convention application. So therefore, very simply, the court, European Court said, European Convention of Human Rights doesn't apply to the Chagos. We don't agree with this because, as I told you, Mauritius and its territories were under the European Convention of Human Rights. And there is a principle that once you give a fundamental right, you cannot take a fundamental right. So we submitted, because we were denied a hearing, we submitted that you can retrieve that right from them, but that was the end of the EU process. UN process, 5 minutes. UN process. Now, UN process doesn't concern us directly. UN process is more about Mauritius against the UK. Mauritius wants to get back Chagos. The deal was, the unofficial deal was the UK would give back Mauritius the island when it doesn't need it anymore. But Mauritius had been asking for the island, get back the island, for the simple reason that there is great economic development in the Indian Ocean that we wanted that. Mauritius is a small island, it's like Hawaii. Tourism, agriculture, and we want to develop in a sustainable way the oceanic industry, but in a sustainable way, and that's our right to do it. And that's why we wanted the Chagos, because Chagos is huge. For the records, I need to tell you, Mauritius doesn't want America to leave Diego Garcia. The Chagosians doesn't want America to leave Diego Garcia. Nobody wants America to leave Diego Garcia, except, of course, for the NGOs against military bases and everything like that. There are such NGOs everywhere in the world against bases. But for the purpose of this litigation, none of the parties want America to leave the military base. All they want, the Chagosian people tell you, well, there are 65 islands there. And the US government only occupies 1/3 of the main island. In Germany, in Japan, everywhere in the world, you've got perfect cohabitation between civil population and military bases. Why can't you have it here? And that's a good question. Another simple reasoning is, on all of those islands, of 65 islands, there are sailors who sail around the world, who stop there, and without any problem. The Coast Guard goes and see them, and they do barbecues, volleyball parties, and everything on the island. So the Chagos Island, they say, why can't they be there? Why can't we go there? Still no answer. And I promise you, the Chagos Islanders are very peaceful. They don't have any ulterior motive or anything. But so I thought I wanted to do that. So this is about Mauritius against UK sovereignty claim. Mauritius is going under Article 73E that its decolonization is not completed yet, and it is asking the UN to pronounce that the UK should complete its decolonization. And of course, Mauritius is relying on Article 73, Article 1, first of all, of the UN Charter, which I told you about that. One of the purposes of the UN is to build friendly relations among nations and therefore self-determination. Article 73E, which lays down the obligations of the colonial powers to report to the UN about decolonization. And under 73E, there was the UN General Assembly Resolution of 1514, which lays down the obligation. Now, what is the power, or what is the force? I don't know how to say that in English. Mauritius is a French island, by the way. So, 1914. So, what is the binding power of a UN General Resolution? And of course, the UK government says not only we did not participate in this and it's not binding on us, and we submitted that, no, it is binding because 1514 was approved by such a big majority of the members of the UN that it had further to Nicaragua versus US. It had acquired are you familiar with Nicaragua versus US? It's an ICJ case law dated 1986 where the court says opinio juris, which is an accepted state of law, is customary international law. And why is it relevant? Of course, I'm summarizing. Why is it relevant? Because Article 38 of the statute of the ICJ lists down the sources of international law, and customary international law is there. So therefore, a resolution which would have acquired opinion juris status would qualify as customary international law, and therefore would be binding whether you like it or not. So that is the UN case. But again, it's an advisory opinion. You guys are aware of the two jurisdictions of the ICJ, International Court of Justice. One where you've got litigation, and one where you don't have litigation. It's just the court just issues an advisory opinion. And Mauritius could not go before the litigious department of the court because England has to consent to it. So Mauritius went for an advisory opinion. And an advisory opinion is worth what it's worth. And if UK says, go take a hike, it only affects the credibility of the UK. But that's what's happening. Later this year, the ICJ is going to hear submissions and make a ruling.